The Supreme Court is considering a claim against the government which argues that an amendment to Gibraltar's housing legislation, introduced in 2013, breaches a landlord's right to enjoy his or her property as enshrined in the 2006 Constitution. There have been various amendments to housing law in recent years. In 2004 and in 2007, the amendments reduced rent control, effectively allowing a landlord to charge higher rents. Then, in 2013, the law was changed again. It reduced the amount of money landlords could charge in particular flats, those in dwellings built between 1945 and 1959, under any tenancy agreement entered into before the 1st of June 2008. There are other blocks that fall into this category of building erected between 1945 and 1959. But here at the Matilda Francis building, there are 41 residential tenancies and 5 business tenancies. Peter Montegrifo QC and Isabella Lugaro have taken over the claim as the new trustees of the estate of Louis Francis. They represent about 10 beneficiaries of the estate. Appearing for them, John Restano QC and Moshi Levy told the Supreme Court the law already provides for rent relief for those in genuine need. The claimant's lawyers say the value of the whole building has dropped by some £2 million because of the 2013 change of law. They say that the decrease in the amount of rent that can be charged is arbitrary. They say it's unprecedented and an aberration to a scheme which has otherwise seen the gradual reduction of rent control while, they say, maintaining existing rights. On the other side of the argument is the Attorney General's Chambers, represented by James Nish QC and Leslie Ann Sayers. They say the 2013 Act comprises part of a broader scheme of legislative rent control that serves the general interest. A spokesperson for the tenants told GBC their rents shot up in January 2012, in some cases to more than double what they had been paying. One tenant told us they used to pay about £200 per month for their large 3-bedroom flat and were then asked to pay £500 per month. The Supreme Court proceedings list one more party to the claim, one of the tenants, Abraham Serruja.
We applied to the Housing Tribunal so that the tribunal would review the cases. There were 23 applications made. The tribunal saw fit to protect the tenants.
Should the claimant be successful in seeking higher rent, basically, who would be affected by this?
Well, most of the people who made the application would be affected. The people who made the application made it out of necessity and out of need, and not just because they fancied to make an application to a low rent. They just can't afford a high rent.
Since the summer of 2014, the landlord has not been able to charge these higher rates. Tenants went back to what they had been paying. Some of them are pensioners who have lived here for more than 50 years. There are also young families and single parents. They think the higher rent levels would be detrimental to them. They feel it would be a social injustice to allow them to be charged. A demonstration outside the Supreme Court featuring some of the tenants highlighted how they feel they no longer have the security of tenure that was guaranteed previously. The presiding judge, Mrs. Ramaje Prescott, is considering her judgment.